Welcome to the Personal Injury Law Show. This is a show that talks about everything current in the law of personal injuries and relevant to you, the viewer. My name's Tony Carbone. I'm a lawyer of 30 years' experience. With me tonight, I've got a partner in a law firm that deals in insurance work, Nunzio Tartaglia. Good evening, Nunz.
Good evening, Tony. Viewers, welcome.
And also an associate that runs a superannuation department in a law firm, Sarah Snowden. Good evening, Sarah.
Evening, Tony.
Tonight, viewers, have got a show that is must watch. We're talking about the duty of disclosure and if you fail to disclose, what happens to your policies, especially to your loved ones if something happens to you. Before
we kick off, Tony, what's in the news?
Well, Nunz, there's been a lot of stories in the news. In particular, there's this fascinating one of a matter that you ran. It was a fellow that sued the neighbours after he injured himself on a fence when he was using his tractor.
Yeah, Tony, look, it's just been issued in the court, so I can't say too much, but yeah, this unfortunate incident involved my client where he was on his tractor at his property and was on the tractor. Unfortunately, the grass was quite high. His neighbour's fence was in between the grass, couldn't see it. The wire snagged his leg, took him off the tractor, and unfortunately the blades of the tractor effectively cut off his leg. So he's an amputee on one leg, got a prosthesis. So it's a nasty, nasty accident, Tony.
Sarah, it's a hidden trap. You've got this wire that's you can't see, so there's an obligation on the owners of the fence to maintain.
Yes, Tony, definitely. Neighbours have definitely got an obligation to maintain their fences, particularly when it's adjoining another property.
So, Nunzio, I think that liability is good, but we'll come back to this as it's subject to the courts at the moment.
Yeah, and Tony, look, it's a big case. I said nasty injury, was a mechanic and lost his business, so we're talking a fairly large case.
This is a very, very interesting case because I've just got onto Twitter. A teacher sued a student in a landmark decision, $105,000 damages for defamation.
Tony, it's definitely going to set a precedent going forward. I think it was only a matter of time before something like this occurred, particularly with defamation and the effects that vexatious comments and the whatnot can have on someone's career or on their livelihood. We've seen it recently with some bullying and harassment, and I think that going forward, this is definitely going to be something we see a lot more of.
Nunz, there's more ramifications than just getting sued for defamation. You could also be charged criminally if there's bullying involved, correct?
Oh, of course. So it's not only civil remedies, but also criminal remedies. And look, you've got to be careful. And I said social media is becoming more and more pronounced as society, increases. So.
Well, with Twitter and Facebook in particular, you've got to be extra cautious because the problem is that anything you send to someone could be on-forwarded to other people. Of
course. Yep. Well, look, in this case, though, the particular defendant was warned about his comments on Facebook and Twitter and still refused to, I suppose, stop the defamatory comments. And basically, I don't want to quote what he said, but he basically didn't care at all. And that's why I think the court punished him accordingly. So.
Yeah, I think it's appropriate, especially in this day where society's moving forwards. We've got a lot more social media. We've got the iCloud and all this other business kicking in. So we're really good to be on top of it to make sure that people conduct themselves appropriately. Isn't that correct, Sarah?
Absolutely, Tony. And the fact is too, is that once it's out there on these social media sites, it's there for everyone to see. People can repost it and repost it. So it does have the potential to cause an ongoing effect.
Well, I mean, defamation, you disseminate the information to the whole world, really, aren't you? Let's keep moving. There's a teenager that sued her parents. She wanted them to buy stuff for her and they said no, so she sued them for it.
So this is a really interesting case where, based on the facts of it from the article, it seems that the parents have set down some ground rules which she wasn't going to comply with, or she didn't believe that she had to. So she subsequently moved out, but has sought from her parents payments for her schooling and out-of-home living expenses. And
she lost her case, but
deservedly so, Tony. Look, it happened in the States, and all I'd say, I think she's a spoiled brat, and just because she didn't get her way at home, she wanted to. She sued her parents for private school fees. Now she wants to sue for college fees. Waste of time.
Let's say she was underage, she wasn't 18. Do you think they had an obligation to pay? Because she was 18 years of age.
No, look, I don't. So the fact is they've created rules at the home, and she's under their care and roof, and they got a cord by that. So I just think she doesn't like what her parents wanted to do. I think because also they wanted her to split up with her boyfriend, and she wouldn't do so. If you could sue for that, then it'd just open up the floodgates.
Well, exactly. There's a quote here that says there'd be a 12-year-old saying, I want to sue for an Xbox. A 13-year-old that says, I want a 60-inch TV. You know what I mean? So
look, the judge made some very fairly pointed comments towards her, which, look, I think was deservedly so.
Kids, behave yourselves, listen to the ground rules, make sure that your parents set certain guidelines that you follow, and then you might get your Xboxes and TVs and whatever else. Let's go on to this. Do you believe that slow drivers should be prosecuted, Nunz, on roads?
Look, I do believe so, Tony, because I said, look, obviously we know that if you speed, that can cause accidents and the like. And I do also think that slow drivers can do that also, especially when it's so, I suppose, pronounced in the sense of doing 50 kilometres in a 100 kilometre zone on a freeway. That can cause serious
I can
damage.
see on a freeway it being very, very dangerous.
Yeah, look, I think you've got to look at the facts of it, but I think it has to be an issue of concern.
My concern, Sarah, is that usually when someone's going very, very slow, it's in the fast lane on a freeway.
That's usually the case, Tony. And unfortunately, the problem with people going so slow, and like I said, in this case, they are looking at people going significantly under the speed limit, not just 5 or 10 Ks, that it creates a frustration with other drivers that then may overreact, and that's what the concern is obviously going forward as well, is how other drivers will react to that, and they may potentially take adverse action to get around a slow driver that may create an accident.
Or a very dangerous situation, because you've got the driver in front, you're behind, then there's drivers behind you that could be running into the back of you, so it becomes very dangerous, doesn't it?
It's a difficult one because obviously, if you're going 50 Ks over limit, there's certain, obviously penalties associated with that, but what's a penalty of going 50 kilometres under the limit? It's a difficult one.
I don't know if viewers know, but when you're driving on a road with more than one lane, you're supposed to stay in the left unless you're overtaking. So that's another issue that people don't realise. Give us your Facebook and Twitter comments on this one. This is a very touchy subject. You've probably got elderly parents and people like that do generally drive a lot slower, but we'd like to hear what you've got to say about it. Nunz, this is one right up your alley. We've got a lady that's issued proceedings in the federal court against her former employer under general protections. Yeah. And what did the judge say about her?
Well, basically, she's self-represented and she's suing for, I think, around $2.1 million. So we're talking a hefty damages claim. And she really, by the looks of it, doesn't really know how to run her case. And Justice Christopher Jessup of the court said she was out of her depth and needed a lawyer. So it just highlights the fact that self-represented litigants, unfortunately, you do need a lawyer because it's a difficult process, and if you're out of your depth, you will get exposed.
And Sarah, listen to these comments. He said, you're in the big league now. You don't get behind the wheel of a Formula One racing car if you're still on training wheels.
It's definitely an interesting comment, Tony. I think what's really important here is to seek legal advice if you've got a legal situation. Not only will it make the process a lot more efficient, but it'll certainly make sure you're getting the right advice and pursuing all your entitlements.
Well, look, the sad thing about this case, Nunz and Sarah, is that she was on a lot of money, and if her claim does succeed, it's potentially a very big claim, so you'd be mad to represent yourself.
Because damages are uncapped, as you know, so...
Viewers, we've got to get our sponsors break. Stay tuned. After the break, we're going to tell you about what not to do when taking out superannuation and insurance policies. Viewers, welcome back to the show. This is the episode that we're going to talk about what your duties are when you're taking out superannuation cover and or income protection cover. It is a must-see. Sarah, what are these insurances I'm talking about?
Tony, through superannuation funds or through retail claims, people will generally or should definitely have insurance to cover themselves in case of injury illness or just a temporary disability that will stop them from working for some particular time. So in particular, the large ones are a total impairment disability or TPD benefit, which is the lump sum that people are entitled to.
Usually those policies are attached to their superannuation premiums that are paid by the employer. Is that correct?
Generally, yes. Generally, they are attached to a superannuation policy. People can take them out separately, and in most instances, income protection will require that someone takes it out separate to their insurance.
And they're in addition to the contributions made by the employer.
That's correct, Tony.
Good point, Tony, because I find that when we see clients at the firm that the misconception is, you tell them that you've got rights under their superannuation policy, and they're like, no, I've already taken out, a lot of my money that I've put in. It's on top of that.
Yes.
A lot of people just do not realise that you've got an insurance component on top of whatever, the hard work you've already performed and the premiums have gone in.
And in fact, viewers, in some instances, the insurance policy attached to your super fund is sometimes better than your common law case that you go to see the solicitors for. Isn't
Absolutely,
that correct, Sarah?
Tony. They can be substantially large.
And in some cases, Nonce, there's more than one policy because if you've changed employment 5 times and you haven't rolled the policies over, you could have how many covers? 5? 4,
Yeah, absolutely,
5, 6?
absolutely.
And you're entitled to claim on all of them.
If there's insurance cover attached to that membership with that super fund, absolutely.
And usually there is insurance cover, isn't there, Sarah, unless you've let the money run out.
That's right. Most of the industry funds will automatically give acceptance for insurance. As long as the money in the account to keep paying and maintaining that insurance, they'll keep maintaining.
And Nonce, if there's no money in the account, they'll write a letter to you saying there's insufficient funds, and it's up to you to top it up.
Yeah. Tony, that brings into an interesting issue when you do have some clients that sometimes roll over their, obviously, funds into one, where some just leave the 4 or 5. It's a interesting, I suppose, issue for clients whether you do that or you just leave your 5 policies to stand. And, Sarah, you've come across many clients that have had 5 or 6 and received, a lot of entitlements associated with it.
That's right, Nunzio. I've got quite a few clients that have had 3 or 4 claims and we've been successful in actually obtaining the full benefit on those 4 or 5 claims.
Well, I had one many, many years ago. Seen I've been around a lot longer than you two. Where the client got 150 grand common law damages and in addition with 4 policies picked up another $750,000. And he blew it in 5 minutes. No, that's another story. But it just shows you there's some very valuable benefits, isn't that correct?
Yeah, absolutely.
They're very lucrative.
All right, let's keep moving. What is the major problem, Nonce, when someone applies for insurance or superannuation, where are they getting tripped up?
Effectively, Tony, non-disclosure, misrepresentation, however you want to define it, but basically claimants or applicants are not telling the funds about their past history.
All right. You've gone very heavy and said non-disclosure, misrepresentation, fraudulent statements. Sarah, it's not really that, but that's what the courts say when you do put in a claim. Isn't that correct?
That's right, Tony. So there's legislation that requires that all members that are taking out insurance, where they're asked questions, to disclose all their past history in terms of medical conditions. And that's where a lot of people are getting tripped up because they're sort of deciding whether or not they should tell them this or should tell them that or that's not relevant. And it can turn out to be a misrepresentation or a non-disclosure, particularly if you've done it deliberately, and then you can get in serious trouble when you go to lodge your application.
Or the point of the matter is this, you might think it's not relevant, viewer, and then you'll find it down the track when you do lodge a claim, in some shape or form it does become relevant.
Yeah.
And then the insurer will waive the policy.
Well, Tony, when we're talking offset, you made a good comment about, a lot of people just go to the doctor to say, look, I'm not feeling great, I'm a bit stressed. Is that regarded as some form of depression and should you be aware of that? And arguably the insurer can look into that.
Well, stress or anxiety or whatever you want to describe it, because there's so many different forms of it, sadly, there's 2 million people in Australia that got some form of anxiety at some point in time, and 1 million with depression. So I would think in some instances it would be a problem. Sarah, case on point, Fraser National Mutual. Can you give us the facts?
Yeah, absolutely. So Mr. Fraser was a fire shot employer who worked in the mines. He went and took out insurance. Now, he disclosed the fact that his job was quite dangerous and they put an exclusion on explosives. So anything that happened to him in relation to that. Now, this...
In other words, if he blew himself up, he wasn't covered.
That's exactly right. Yeah. So this one had a particular difficult set of facts in that he put his credit card up, they paid a premium. The insurer subsequently sent him out a questionnaire to answer.
Yep.
He's signed that piece of paper declaring everything on there and has then gone on holidays. And in between the fund receiving that, he has gone to his doctor suffering from major depression. Now, the issue in this case was that happened in between the payment being made for the premium and the insurance cover actually being accepted by the fund.
It was only 8 days.
Yeah.
Give us a time frame between him lodging the application and him being diagnosed with depression.
Well, he got diagnosed with depression, I think it was the 4th of January 2008,
That's
and his claim was effectively, or the policy of insurance was accepted on the 11th, so 7 days before effectively it was accepted.
To get the exact time frame, 11th of December he makes application, 21st of December 2007 he signs a document headed acceptance of revised terms form, and then on the 4th of January he's diagnosed with major depression. So if you want to be cynical or sceptical, looks like there's a cover-up, correct?
Oh, look, I disagree.
Okay,
You're
entitled to your view, but...
I disagree, because I think if there was going to be a cover-up, he would have maybe waited a little bit longer, to be honest. So,
that's a good point.
I just think it was, he thought, as Sarah said, he had his premium taken out from his credit card, so he assumed he had insurance at the time, and then he went to his GP and the diagnosis was made, but I just think it was just bad timing on his end.
Sarah, just curiously, 11th of December, 4th of January, what are we talking? 20 days, give or take?
Yeah, that's it.
Yeah.
That's it. So,
and he's got a major depression.
Yeah, so the problem with it, and this case points it out, is that the duty is ongoing until that insurance cover is actually taken out. So in this case, look, it was just I think it was just bad timing in terms of what happened and what caused the depression. But in any case, insurers are sticking to this, and in this case, they actually wiped out his entire policy. So they cancelled the entire policy on him.
Okay. Nunz, are you aware of him complaining of depression and or anxiety prior to him applying for insurance?
Well, it came out earlier, Tony, that he did complain of, I think it was insomnia and sadness, so he made a few complaints to the GP. And obviously, another issue was the referral to a colorectal surgeon, Tony.
Yeah, I know, but that colorectal doesn't really deal with depression.
It doesn't, but that was also one of the major bases on which they regarded his, I suppose, non-disclosure misrepresentation. And
sadness and insomnia doesn't translate to anxiety and depression?
Not necessarily, but in this case, and as in all cases now, they are looking at that really closely, and the duty is on you to disclose any symptoms.
Viewers, we've got to get our sponsors break. Stay tuned, we'll give you the result of this decision just after the break. Viewers, welcome back to the show. We're doing this case of the non-disclosure. What was the result, Sarah?
Tony, in the end, the judge ended up finding for the insurer on the basis of a non-disclosure of a colorectal issue that the client hadn't disclosed or the plaintiff hadn't disclosed prior to taking out the insurance policy. And the basis of that is that they said that had he disclosed that, they would have sent him off for investigation with a doctor or sought further medical advice from his doctor. And on that basis, the policy would have been delayed, after which time he would have then been required to disclose the depression.
And what's to say, Sarah, and I'm throwing this one at you, Nunz, that instead of complaining of depression on the 4th of January, he would have waited for the results of the surgeon investigating the colorectal problem and then complain about depression a month later?
Look, that could have changed the outcome, but look, it's hard to know if they're both linked, but either way, it's just a lesson to, plaintiffs or clients. Even if you think it's innocuous, and he didn't know on his evidence that, a referral to a colorectal surgeon might be an issue of cancer, and ultimately found that there was no cancer, you just need to tell the insurer, put it out there, because if nothing comes of it, you're fine.
And what's the worst that can happen if you disclose something, Sarah? It's an exclusion in the policy.
That's exactly right, Tony. Generally, they'll either put an exclusion for a particular illness, or if you've had a back injury, they might put an exclusion on back claims, or they'll just increase the premiums that allows you to continue the cover.
And more often than not, that's what's happened, isn't it? Not so increase the premium.
Yeah, look, it's hard for plaintiffs because, the funds will just leave evidence to say this is our usual practice, and plaintiffs can't contradict that, because if that's their practice, that's their practice. So you just need to be open and honest. You may think it might help you, but it usually works the other way if you hide it.
And Sarah, do you find that a lot of the times the insurers the funds aren't investigating any pre-existing problems, and then once you lodge a claim, they go through your history like it's an autobiography?
That's exactly right. Generally, they're not looking into any past medical problems until a claim is lodged, and it doesn't have to be for the same injury or illness that you've lodged the claim for. So you could lodge a claim for a back injury, and if they go back through your policy and say, your medical history, and find that you've had depression or asthma or anything like that you haven't disclosed,
colonoscopies,
that's
and
exactly
this
right.
and that.
They'll go back to the underwriters and they'll say, well, we wouldn't have insured you, or we wouldn't have insured you for this, this, and this, and they'll cancel the policy.
And more often than not, you go to court, and the judges, it attacks your credibility if you've had multiple pre-existing problems that you haven't disclosed, notwithstanding the fact that they're not the reason why you've claimed in the first place.
It's a perception. It shows that you're trying to hide it, you're not honest, you're not open, and the courts don't like that, and these decisions show that they won't find for you.
Now, viewers, you've got to listen to this question. Assuming, Sarah, I've taken out a policy of insurance, right? I've failed to disclose that I've had severe depression, or I've been sad or stressed in the past. My policy is ongoing. What would you do? What would you suggest I do?
If the condition predates the date that you take out the insurance, you really should seek advice about disclosing that. In most cases, they will just put a higher premium in place, or will exclude that particular injury. So you're still covered going forward. The longer you leave it, or if you wait till you make a claim, more likely than not, that is when they'll try to avoid the policy.
All right, let me throw this one at you, Nunz.
Yep.
Assuming you failed to disclose a pre-existing psych injury, and subsequent to that you've developed other conditions, are you obliged to disclose the other conditions?
Look, that's
tricky.
Yeah, that is very tricky, Tony. And what I'd say, you definitely have to seek advice in that regard, because it all depends what the wording of your policy is, and that's a non-negotiable. You need to see a lawyer in that regard, or seek financial advice, broker's advice, because that is very, very tricky.
Do you think there's a lot of people in the community, Sarah, that are uninsured because of failing to disclose? And in fact, you see it every day.
Tony, we see a lot of potential clients that come through the door that haven't disclosed things at the time they've taken out insurance because they don't think they're relevant, or they haven't impacted on their life in terms of work capacity or ability to function or whatnot, so they don't see them as relevant. Comes time when they need to make a claim and they're automatically being wiped out, and unfortunately we're seeing it more and more.
And examples, the next case we're briefly going to chat about, of Phillips, this particular applicant was just asked about, there was a health evaluation form, and it was asked questions according to that form. He answered all those, but then he still had a duty to make sure he went beyond that. And so basically you've got to tell your whole life. It's getting to the point where they're almost got to just openly give their medical records to the fund and say, there it is. Don't you think?
That's dangerous too.
But it's almost getting to that point,
Yeah,
Tony.
it is. The worst thing that can happen, viewers, is if you disclose something, the insurer turn around and say, we'll cover you with the exception that you won't be covered for your back or your depression or whatever. And if you're not happy with that, you can debate it or go to another fund or go to another insurer, correct?
That's right.
Now, Nunz, it's a bit disappointing that the insurers are not doing their homework at the start when you apply, correct?
Yeah, it is, because it gives applicants sort of false hope, thinking they're covered, and if something happens by way of, a cancer or something to that effect, they feel like they've got the security of financial security, but then, by the time you make your claim, they start opening up all your medical history, and you might not get covered, and that's scary for applicants, because that's your livelihood, and you need the funds to support yourself and your family.
And you could be paying significant contributions for nothing.
Like Fraser, he said they deducted premiums and still got nothing out of it.
All right, let's get on to the next case. Phillips and ING Limited. Sarah, tell us the facts.
So in this case, the applicant made a claim for, or his wife, the applicant made a claim for a death benefit after her husband died of esophageal cancer. Now, the problem with this claim was it was insured for $700,000, so it was a massive, massive amount that he was insured for. Now, they have rejected the claim on the basis that he didn't disclose the fact that he had esophageal tests regularly in the past.
And regular gastroscopies.
And regular gastroscopies, so that wasn't disclosed. So obviously they've tried to avoid the policy, and the applicant has made a claim in the court. Now, in this case, the the insurer reduced the claim to an amount. So they didn't completely cancel the policy, but they reduced it by what they believed would have been an increase in premiums and a more accessible risk for them in taking on his claim or his insurance cover had they been aware of that condition.
Nunz, I think the spouse was lucky to even get any money in this case. Do you agree?
Yeah, look, I agree. Look, we went from basically 700 grand to, I think, 466, and still a fairly good result considering he knew he had Barrett's esophagus. He really didn't disclose it. Was still undergoing tests, and look, very, very lucky, and still considerable amount of money.
Yeah, look, I reckon I reckon the spouse was very lucky, and it seems, and if you look at the timing of this, from the date that he applied for insurance and he died, it was about 8 months. So it creates suspicion. We're getting towards the end of the show. Sarah, what would you advise the viewers if they've got these sorts of issues?
Tony, I would definitely advise our viewers to seek legal advice on these issues, particularly where they feel that they've disclosed something to an insurer and then when they've gone to make a claim, perhaps that the claim has still been avoided, that they've still avoided the policy. They should definitely seek advice. Also, if they're unsure about whether or not they've disclosed the correct things to the insurer, they should definitely seek advice.
Okay. Nunzio, you also head up the insurance department of Wiki Carbone.
Yeah.
Is there anything else you'd like to add?
Oh, look, as you said tonight's been such a, I think, interesting episode because it brings up so many issues when it comes to superannuation and the policies, and it just highlights the importance of seeking legal advice. And look, we've got a massive department of superannuation at the firm where we operate thousands of claims. So come see us because it's very, very important.
Nunz, Sarah, thanks for coming on board.
Thanks, Tony.
Viewers, go to our past episodes, stay tuned for future episodes, and always remember to stay safe.